Good evening, ladies and gentlemen. I'm the ghost of Smedley Butler here with the ghost of Judge James Horton. How you doing, Judge?
I'm good, Smedley. How are you?
Good, good. And we are the Yellowhammers. And today we're going to talk about some local issues, specifically an incarcerated prisoner on death row. Is that right?
That's it. You know, we had talked about it. We want to kind of do one national, international issue and one local issue a week. And so, you know, we this week we also covered the thing in the news with Hunter Biden, criminal justice issue. So I thought maybe covering a local criminal justice issue would go nicely with that. Have you ever heard of Toforest Johnson?
I'm not intimately detailed with it, but I kind of vaguely know about it. I believe he's a death row.
He is.
He's on death row. Yeah. And there's been some real issues with the prosecution in that case. So much so, I believe the original prosecutor has wrote an amicus brief on Johnson's behalf.
So the original courtroom prosecutor, has come out against the prosecution, and the sitting district attorney in this jurisdiction, Danny Carr, has filed the amicus brief asking that the conviction be overturned and he get a new trial.
Wow. So what were the charges?
So in 98, there's a Jefferson County Sheriff's deputy. He'd been in the force a long time, but if you know any law enforcement officer, you know that they work these side jobs where they
security.
Yeah. They get paid pretty well to direct traffic at church or what have you. So this guy's working one of those jobs, and he's a security guard at a motel or a hotel or whatever the difference is. I can't really tell you.
Oh, I can tell you. A hotel has a lobby, and you have to go through the lobby to get to the rooms. A motel has no lobby. You drive your car right up, and the door faces directly to the street.
I'll be damned. Yeah. I learned something today.
You're welcome.
Hey, I know. That's why we tune in here. You get the hard-hitting stuff. So, yeah, he's this says hotel, but who knows. So he's a security guard there, and he ends up shot and killed. There are 2 shots fired. They find 2 9mm shell casings that match the same gun. The gun is never recovered. The deputy, William G. Hardy, is shot 1 time in the head and killed.
Oof.
So what happens then, they start investigating. They put out all this news about it. They put out details of the crime. And even law enforcement at the time made a statement that there's too much news out there about it, that it makes it hard for us to know if someone that calls and gives us information.
You got a dead police officer, so.
Yeah.
Yeah.
But they say that it makes it difficult for us to know that if someone that calls and gives us information actually knows something, or they've just boned up on the police reports and what's been in the news. So the entire prosecution is based on 2 witnesses. The first one is, we'll deal with Yolanda Chambers. She was a witness that claimed to be an eyewitness to the shooting. And so she said a bunch of different things. She was interviewed by the police 20 different times.
20 interviews?
20. 20. Which was shocking for me. I've never seen a person.
Well, that means the cops had to keep coming back because there were holes in the story.
Well, they didn't believe what she said. And she ends up fingering 4 or 5 different people for the murder. She ends up saying that several different people were the trigger man.
Offer?
Oh, there was. And we're going to get to that.
Okay.
You correctly anticipate one of the key turns in this story, my friend. So this lady says that she was with Johnson, this guy named Ardregus Ford, and a LaTanya Henderson at a hotel on the night of the shooting. She first stated that Deputy Hardy came out of the hotel and Ford shot him once. Startled, she turns and looks away, then heard a second gunshot. And then she didn't see who fired the second shot. She admits to lying to the police on several occasions during investigations and in implicating several different people in Hardy's murder. At least 4 different individuals she says she saw pull the trigger and kill this man. She told on different occasions that she said Johnson did it. She said a man named Omar Berry did it. She said that Ford did it, what you just heard. And so on the date of the trial, she says, yeah, I lied all those other times, but I'm telling the truth this time.
Is there any motivation for that?
Not for her.
Okay.
Individually. She said a dude named Henderson had been the trigger man. She gives all these wildly different stories. And the one thing that shouldn't change is who pulled the trigger. right? That should be the one part that is consistent. If you saw somebody pull the trigger, who was it? You know, does the date change, or does the particular time of night change? Does where they were standing change a bit? Does the exact sequence of events, do you expect that to change from an eyewitness?
But not only did she see who pulled the trigger, she had last names and first names, so who pulled the trigger, but then decided she needed to lie.
Change the story several times.
Yeah. Was there any like relationship between her and Johnson?
Not that I'm aware. Not that any of the. And so where I got all this information from were the appellate briefs.
Okay.
Right, because on this podcast we pride ourselves in going straight to the horse's mouth and getting it from primary sources. You know, what do they say? Not what does some reporter paraphrase, but what do the pleadings say? And so this other witness, and I'll get into what Danny Carr says about it, the current district attorney in Jefferson County.
Did you read the amicus brief?
I read the amicus brief, and I've actually got it with me.
Oh.
Yeah. Okay. So I think the best evidence is going to be what Danny Carr says, because he's the state. He's the elected district attorney in Jefferson County. So if anyone had any sort of motivation to point out the strengths in the state case and minimize the weaknesses of the defense, it's him.
Right.
And he doesn't do that. The second witness is a woman by the last name of Ellison. And this is bizarre. And this happens on a regular basis. So this first part, I can tell you, is common practice. When you make a call from the jail, you use a PIN number, and all these calls are recorded. A lot of times when there can be several situations. It could be that they want to talk to multiple people without spending, money for multiple calls, or it can be that they don't want the person that they're dialing to show up on the call logs. So what they'll do is call somebody and three-way call other people in.
Right.
So this woman, Ellison, testifies that her daughter was making these sort of three-ways calls for people in the Jefferson County Jail. She lays the phone down and walks away. Ellison, for no reason that I can tell, picks it up and starts eavesdropping on the phone calls, and here's a person who identifies himself as Toforest say that he's the one that shot this Deputy Hardy. And this is where the reward comes in. This woman inquires about a reward and is paid $5,000 for her testimony. None of that is disclosed to the defense counsel. None of that is put before the jury.
I think that's pretty big.
That's a Brady violation.
Yeah.
So the fact that she was paid for her testimony and was a witness for the state in several other cases, many of which were dismissed for lack of evidence, all leans towards the fact that neither one of these witnesses were credible. You combine that with the fact that several affidavits were executed, and Danny Carr points this out, where upstanding, good-standing citizens of Jefferson County are swearing that Toforest Johnson was with them on the night of the shooting.
So he had an alibi?
He had an alibi, and several people that vouched for that alibi. At trial, the defense was essentially twofold, and you can argue inconsistent defenses, right? You can say that if you believe this happened, then he's not guilty because of this. But if you believe this happened, he's not guilty because of that, right? Depending on whatever you as the finder of fact as the jury believe. And so he argued a couple different things. One was essentially that this Yolanda Chambers woman said, identified Ford, said that Ford's the one that shot him. It was somebody else. The second one was all these alibi witnesses. And so if we turn to what Danny Carr says about it, and I think, first off, let me get your comment on all that before we move on to Danny.
Oh, man. There's no forensic evidence at all.
None. Never recovered the gun. No video.
Okay. No video, no gun. You just got a body with two 9mm shells.
No fingerprints. Okay. And so,
and you've got one supposed eyewitness.
That
has identified four other people before identifying Johnson.
With several different stories, and even one of the stories said that one person shot him the first time, and then another person shot him the second time. Well, we know that's not true because the 9mm shell casings came from the same gun.
Right. So she doesn't even remember the facts of what actually happened.
Right.
Well, what the witness is saying doesn't reflect what the evidence it has there on the at the crime scene.
Right, in some of her stories.
Right. So that's your eyewitness who's not like, but she was there. Is that right?
She says she was there. Toforest Johnson says he wasn't. So for the whole time, he's maintained as innocent. He said,
but was she there? Was she on the premises?
she says she was, but when police arrived, she's nowhere to be
There's
found.
no other corroborating witnesses saying that she was there?
Correct.
Okay. That's even more sketchy. And then the third party on the phone.
Yeah, the ear witness, if you will.
Yeah. That screamed. Who was the original prosecutor in this case?
I forget the guy's name. And if I can pull it up here, I'll tell you. But the original courtroom prosecutor, there are assistant district attorneys who try cases, and then there are elected DAs that are administrators and politicians. The assistant district attorney who tried the case back then is pro overturning the conviction, as is the current elected DA.
But who actually tried the case? Do we know?
I did earlier. Hang on a second. I can probably tell you.
Because what I'm thinking here is, if you've got a witness,
Jeff Wallace
was
the guy.
Do we know what Jeff Wallace has to say about all this?
Oh yeah, he he led the prosecution of Johnson, and he's called for a new trial.
So he has called for a new trial.
Yeah, the actual courtroom DA that secured the conviction has asked for a new trial. And by the way, the state initially indicted 2 other people for the murder, not Toforest Johnson. They tried someone else for the murder as well. The other person was tried.
All right. How many people can you try for one murder?
Unlimited amounts. You're allowed inconsistent prosecutions, and the state did here. When they prosecuted this Ford guy, they said Ford's the trigger man. He's the one that did it. When they prosecuted Toforest Johnson, they said Toforest Johnson is the trigger man. He's the one that did it.
Were you allowed to enter that prior testimony into this case?
I don't have that transcript, so I can't tell you.
Okay.
I mean, you should have certainly been able to argue it and put it before the jury.
Yeah, because you've got the prosecution trying to have its cake and eat it too right there.
Right. And so the first time each of these men were tried at mistried, the second time Ford was found not guilty and Toforest Johnson was convicted of capital murder and sentenced to death on a 10-2 verdict.
So I'm still caught up on this.
Yeah.
Hypothetically speaking, let's say you have a prosecutor charge 2 different people for the murder of the same person, both being the trigger man. And the evidence specifically states there's only one gun. Let's say both are convicted. Is that automatic grounds for appeal?
No.
No? Okay.
No. Both convictions can stand, as bizarre as that sounds.
So both convictions can stand, even though it's evidentiary not possible for that outcome to occur.
Correct. I know. Wild, right? Terrifying.
It's supposed to be, the law is supposed to be based on evidence. And if you have convictions based on conflicting evidence, that doesn't sit right with me.
It doesn't me either. Never has. But let's talk about what Danny Carr says about it.
Okay. Talk to me, Danny.
So, in the amicus brief, he gave 5 reasons that there should be a new trial. He said there were several trials of different individuals relative to this case. Pursuant to these trials, the state presented as many as 5 different theories relative to who shot Deputy Hardy. And that's the sitting district attorney that said that. The original case was based on a young lady who admitted repeatedly lying to the police and prosecutors as well as under oath. 3, there are a number of alibi witnesses who did not testify at trial, whom claim to have seen Mr. Johnson in another area of town at the time of the murder. 4, the main witness who testified to hearing the defendant admit to killing Deputy Hardy over a telephone conversation was subsequently paid $5,000, which was never mentioned in trial. And 5, the district attorney, prior to filing this brief, met with the original lead prosecutor in the case. He expressed concerns about this case and supports this request as well.
Okay. So the current DA, the former prosecutor, have all come forward and said this conviction was shaky at best, or was all based on bad evidence.
Right.
And
he's still on death row awaiting
Yeah.
execution.
Right. So who filed the appeal?
So EJI, various defense attorneys, and I actually want to read a quote from Danny Carr, who was recently at the Tabernacle Baptist Church in Birmingham speaking about it. And he said, "The evidence in this case has unraveled over 20 years. It has not been possible until recently to fully appreciate the full extent to which the foundation of this conviction has disintegrated. The jury and judges who previously assessed this case did not have the benefit of all the information that we have access to now." And it's interesting that he says the jury, because some of the jurors in the case have written opinions or op-eds in various publications where they call for the conviction to be overturned. These are the very people that rendered the guilty verdict.
And this is before the Supreme Court of Alabama right now.
It's pending before the Court of Criminal Appeals at the moment.
Okay.
And so the obvious question is, well, if everybody agrees, what's the big damn deal? Why don't we just let the guy out and have a new trial?
Yeah, we don't let people off death row in Alabama.
We don't. And they look to procedural reasons. They say, look, a judge has already heard this. It's already been argued, and they ruled against you. Tough shit, right? And it's the Attorney General's office. It's Steve Marshall's office that's arguing it for the state. It's not Danny Carr.
Right. So is Steve Marshall's are they arguing vehemently to keep him on death row? Or?
Absolutely. They're saying that no court has jurisdiction to overturn this conviction at this point. They're saying that Toforest Johnson.
Oh, come on. That's absolute bullshit.
They're saying that
The Alabama Supreme Court has absolute jurisdiction to overturn this thing.
or you would think SCOTUS would, right?
Yeah.
But what they're saying is procedurally, and I actually spoke with an appellate lawyer before we did this, who agreed that procedurally that's his biggest hurdle, is arguing that he hasn't already exhausted those remedies. That he's not already, been through every procedure he can to attempt to overturn the verdict, and that he's got to. If I had to place money on it, I would place money on the state of Alabama killing Toforest Johnson.
Even though they know all this evidence has come out.
Yes.
Post verdict.
Yes. Absolutely.
I thought that was the reason for an appeal, is for exculpatory evidence post verdict.
One would think. But it's people don't understand. If you file an appeal, and I'm not exaggerating when I say this, people when they make up statistics, it's hyperbole most of the time.
Right.
97, 98+% of appeals are not successful. The court gives extreme deference to the trial court decision. I mean, that's why we get. If you don't think we have innocent people,
unless you're Alabama Power, then you're
that's true.
Perfect on appeals.
Or unless you're a personal injury verdict in Alabama,
no, that'll never stand.
That's getting reduced.
Yeah,
every time.
Just like FDR, that'll never stand.
Yeah, but man, polio jokes. That's what the people come for, But yeah, particularly criminal convictions are next to impossible to overturn, and part of it is, we in America like to think, oh no, we got the greatest criminal justice system in the world. We get it right, baby. And if we start overturning these convictions, what message does that send?
The problem is ego.
It is.
Like the state has this invested ego of just, if we say we're wrong, the system will break down and people will judge us going forward. That's already how it is. DNA evidence blew that out the water years ago.
Right. Bite mark evidence is not admissible anymore. Shaken baby evidence is going to go the way of the dinosaurs soon.
What about lightly stirred baby evidence?
Yeah. That's still admissible.
That's still admissible?
Yeah.
All right. There's the Supreme Court of Alabama is there to take care of the large political investors that got them elected.
That's it.
Mostly the Chamber of Commerce, a lot of doctors, insurance companies. Oh, they love the Supreme Court of Alabama.
Certainly not poor minorities. I guarantee you that.
Nope. Well, that was the one thing about Judge Roy Moore, is that he was not beholden to any financial interest. He was straight up there on a populist vote, on the religious populist vote, but he actually had some really, really interesting.
He was pretty good for criminal justice, actually.
Yeah, and not just criminal justice, but like civil plaintiffs work as well.
Here we are defending Roy
writing
Moore.
dissenting opinions about just an egregious Supreme Court decision by Alabama, and you're just like, Roy Moore, okay, all right.
The year is 2024, and you and I are defending Roy Moore. That's where we've got to. Speaking of, so recently he went before the parole board to argue in a parole hearing for clemency, or not clemency, but for parole for a non-violent offender who had already done 20 plus years, like a long time for a petty crime. And they just crucified him. Lee Gwaltney was awful to him.
Yeah.
And ultimately denied parole, where you had the former Chief Justice of the Alabama Supreme Court absolutely going to bat for a guy.
I heard she literally embarrassed him in front of the parole board.
Yeah. And ridiculous stuff, like asking him to quote the specific statute. And come on. We know what the elements are. She's a nightmare. She's an absolute monster. But that's not the point of this conversation. The point is Toforest Johnson and the fact the state's probably going to murder him for something he didn't do.
Probably going to do some weird experimental murder.
No doubt. They'll nitrogen gas him.
Why can't we just kill him normally? Why do we have to experiment with gas?
So the real answer, the companies that make the chemicals they use for lethal injection, their shareholders don't want their products used for that. So they refuse to sell it to the state.
Ah.
Uh-huh.
Okay.
Interesting, huh?
Yeah. That makes more sense now. So Alabama can't get the drugs to execute people, so now they're making stuff up.
Right.
Good for them.
So we're doing this nitrogen thing now.
Yeah. What?
I know.
Good Lord.
But
the guillotine was fine.
Probably less cruel, honestly. Yeah. Way more messy. Did you know that the last person to be executed by a guillotine was in the 1960s?
Yeah, it was way recent than you realized.
Right.
I think somewhere in France.
That was definitely France.
Was it France?
Yeah.
Yeah.
After World War II, I think it was 1961, but don't hold me to it.
Good for them.
I know, keeping at it. But the point is what you said. People think that if we get it wrong at trial, they'll fix it on appeal. Bullshit.
And sometimes you get a judge that just won't take your side.
Yeah.
That just happens.
Well, and here it's going to be on procedural grounds. It's not based on the fact that what they're saying doesn't have merit. It's not based on. If the sitting prosecutor who's elected,
you and I both know the judges are looking for a way out.
Absolutely,
they don't want to have to deal with this.
Absolutely,
and the whole reverse remanded no opinion is some of the greatest bullshit I've ever. So for you people out there that don't know, the Alabama Supreme Court can take a jury trial verdict, reverse the decision, remand it for a new trial, and they don't have to write why. So if there's a big big jury verdict in some sort of civil action, they'll reverse and remand that decision by the jury and not have to justify their reasoning. And call me old school, but if you're going to destroy someone's verdict, you need to tell us why.
Right. You have some sort of indication. That's what justice is.
Yeah. So I don't know how it works on the criminal side.
The same way.
They can reverse and remand, no opinion?
Absolutely. The most egregious one for me is for a long time, you haven't been able to sentence juveniles to death, but you've been able to sentence them to life without parole. And I think it was back in 2012. There was an Alabama case where the United States Supreme Court said, no. For juveniles, if you're going to sentence them to life without parole so they never get out, you have to have a hearing to determine that they're basically irreparably corrupt, I think is the language that they use. And otherwise, if they're not, and that should be the rarest of cases, and if they're not irreparably corrupt, you sentence them to life with the possibility of parole. So that they start having what they call Miller hearings, and judges are doing the Miller hearing and then denied. And they sentence them to LWOP. No opinion, no reason that they're irreparably corrupt, just opinion.
Well, you used a term there,
LWOP, life without parole. Yeah.
Nerd.
I know. So judges weren't issuing an opinion about why they found what they found. They were just denying Miller relief and sentencing him to life without parole. So in Montgomery, it's a different case. It goes up to the court, and all they're saying is, justices, if we're going to have a meaningful right here, you have to make them list why.
Wait. Are you making the judges work?
Oh, yeah. Trying to.
You can't do that.
It didn't work.
No.
You correctly anticipate where this is going. So the appellate court said, no, you do have a right to have this hearing. And yes, only the most irreparably corrupt or irretrievably corrupt are eligible to be sentenced to life without parole. However, we're not going to make you do a finding of fact so that it's not appealable. I mean, you know this. You can't appeal denied.
Yeah. Whew. Yeah.
And it's sort of the same thing here. Like on a procedural ground, they're saying, all this has been heard, a judge ruled against you. Tough.
Well, obviously, it's not been. There's evidence that has not been heard.
Some of it was heard on they call them Rule 32 petitions, like what they call ineffective assistance of counsel.
Right.
And so some of it was heard on that. But what hasn't been heard is the district attorney, Danny Carr, coming out and, filing this amicus brief, which...
That should carry a lot of weight with the court. It should, but it won't.
Right. The community support, the original prosecutor coming out like that, the fact that they've now found the check where the county paid her $5,000 that could have been entered as an exhibit.
Was it not? I mean, the Brady offense alone
should have been enough to overturn it.
Right. Have they tried appealing it to the Supreme Court?
They've gone all the way to the United States Supremes, and all it was remanded for hearings on certain issues. Which
on the Brady issue, was it remanded?
Yeah, which the trial court judge in Jefferson County ruled against Toforest Johnson. She's no longer on the bench, the judge that did it, and it's back before Judge Candace Pickett here in Jefferson County, who's a fantastic judge, on another Rule 32 petition, what they call a successor petition, right? It comes after, and the current brief on that petition before her is that you don't have jurisdiction to enter an order on this because the appellate court hasn't ruled on the last one yet.
Oh, come on.
I know. I know. So I think the most likely way that he gets some sort of relief is if there's an agreement by the state and the defense on what's supposed to happen, or like even time served, right? Let's say we reduce it to murder and then you've been in there.
Steve Marshall and those guys to get together and do something.
Which is not going to happen.
Yeah.
Which is not going to happen. Steve Marshall's a political animal.
Yeah. I mean, that's...
Out of all the people that have Alabama's best interests at heart, that man is not one.
Well, anything else you want to add to Forrest Johnson?
I mean, just... Google the man if you want to get involved. ToforestJohnson.com. EJI's got stuff about him. I think they're involved at this point. Have been for a while. Kay Ivey has the ability to pardon him because it's a state offense. We've been talking about pardons today. So, if it's something you're passionate about, send letters, get involved. I mean, because I think it's pretty likely that we're going to murder this man.
Welcome to Alabama, guys.
Right, roll tide.
War Eagle.